A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Thanks so much for tuning in to another edition of Bearing Arms Cam and Company, the very first Bearing Arms Cam and Company for 2020. Hopefully you had a safe and happy new year. It was very low-key at my place. Didn't make it till midnight. We were going to set off fireworks. And even though I live in the middle of nowhere, I just always feel bad because I assume that my neighbors are not up at midnight. And I think I was probably the only one in the county that actually did not set off fireworks. So I have fireworks to set off randomly some occasion. Maybe, I don't know, maybe St. Patrick's Day. Maybe Valentine's Day. Maybe I'll just put on a fireworks display for the lovely and talented Miss E there on February 14th. Now, coming up on the program today, Second Amendment attorney and scholar Steve Halbrook is going to join us. He's got a great piece at the Independent Institute talking about what is going on with the Second Amendment sanctuary counties and the fact that the very first Second Amendment sanctuary actually took place in Virginia in 1774, before we even had a Second Amendment. What do you think about that? And in fact, let's get to our interview with Steve Halbrook. Take a look and a listen. Well, Steve, Happy New Year to you. Thanks so much for coming on the program today.
Glad to be on the show as always, and Happy New Year to you and all your listeners.
Thank you so much, sir. You had a great piece at the Independent Institute the other day talking about how the very first Second Amendment sanctuaries in Virginia date back a lot farther than what we might think, going all the way back to, 1774?
That's right. What was going on then, most of the action was in the colony of Massachusetts, the British taking severe actions up there. There were some armed conflicts. This is still a year before Lexington and Concord. But it was going on in all the colonies, and we had our last royal governor here in Virginia, Lord Dunmore, was doing things to fulfill the British ministry's policy of disarming the population, because there had been the different protests, the Tea Party and all of that going on, and the British were clamping down. And so in late 1774 and then early 75, you had the origin of independent militia companies formed by Patrick Henry and George Washington, and you had George Mason talking about how they were formed to protect the rights of the Englishmen, the civil rights that they felt they had. And so Dunmore goes, and they had a big powder house in Williamsburg, and he had the gunpowder taken to a British warship. And of course, the people in Virginia thought, well, you're stealing our powder. That's for our defense. And he even sent British troops they had an armory there to take all the locks off of the muskets so they couldn't be fired. And so meanwhile, on our side, on the Patriot side, you had the Patriots forming these independent militia companies, and they were basically saying, look, we're not with the Royal Militia. We are independent, and we're protecting our liberties. And so they were basically, as a factual manner, creating Second Amendment sanctuaries, so to speak, because they were making it, their territories were controlled by them. And finally, the governor fled Williamsburg and took residence on one of the British warships, and basically declared war on the people of Virginia.
You know, and it's interesting. I mean, you talk about some of the analogies. I mean, you say that George Mason, talking about the Fairfax Independent Militia Company, said, threatened with the destruction of our civil rights and liberty, the volunteers will each of us constantly keep by us. Was it a musket, 6 pounds of gunpowder, 20 pounds of lead? You say there's a parallel to the large capacity magazines that Governor Ralph Northam and others want to ban. And you also say that it is ironic that Fairfax County is now the center of that blue wave that supports these Dunmore-esque gun bans. You also say that, this is not a perfect comparison to 1774. You say that counties that have declared themselves Second Amendment sanctuaries make clear their dedication to use all lawful means to protect their constitutional rights. Law enforcement authorities have scarce resources and must choose how to allocate them, work to solve murders and robberies, or track down gun owners because they have rifles with those oh-so-deadly pistol grips or adjustable stocks. That is a no-brainer, you say. And I think you're exactly right, Steve. I mean, one of the things that I've been talking quite a bit about here on the program over the last couple of weeks is, Ralph Northam, Mark Harry, and others keep saying, well, these Second Amendment sanctuaries have no legal basis. I don't think anybody is proclaiming that they do. I think that these are petitions to the government, informing these lawmakers, hey, listen, if you continue to go down this road, here are some of the problems that you're going to run into, including in 90% of Virginia's counties now, a populace and officials that do not see these gun control laws as a priority, don't see them as benefits to public safety, and regardless of what legal terminology you want to use, I think in a lot of these counties, the sheriffs, the Commonwealth's attorneys are going to use the discretion that is available to them now to simply not enforce some of these laws.
Yes, if you look at what's being proposed for legislation, it's incredible. It's like a war on law-abiding gun owners. Senate Bill 16, for example, would ban virtually all modern sporting rifles based on the most innocuous characteristics. If you have a semi-automatic rifle with an adjustable shoulder stock, you can get 5 years in the penitentiary. I mean, what kind of people are they that they want to do that to their fellow citizens? If it has a protruding pistol grip, 5 years in the penitentiary. Our side doesn't threaten them that way. I mean, it's incredible. So that's why you see these sanctuaries, or some counties, instead of saying they're sanctuaries, they're resolving in favor of Second Amendment rights, and they're basically warning Richmond, as you said, and exercising the right to petition. And for the Attorney General Herring to say this has no legal effect and to poo-poo it, and to use the term gun safety measures and gun violence prevention measures to describe wanting to put his fellow citizens in prison for nothing, for activity that's been legal in Virginia since it was founded in 1607. I mean, what a sea change that's being proposed. The idea that completely law-abiding people should be incarcerated and get felony records for doing things they've always done and not hurting anyone. So it's an incredible situation.
It is an incredible situation. And what's even more incredible, Steve, is that these same politicians proclaim themselves to be criminal justice reform champions, right? That they want to take laws off the books that are putting young black men in prison for nonviolent offenses. And what are they doing? They're putting a lot of nonviolent felony level offenses on the books that I have a feeling are going to disproportionately impact young men of color in cities like Richmond and Petersburg, Virginia Beach, and other places.
Yeah, and let's look at what's proposed and how practical it is. In countries where they've confiscated guns, look at New Zealand. The deadline passed a couple of weeks ago to turn in all the semi-autos. And there they don't even have a Second Amendment right. And also there they were compensating them for them. And only about maybe a fourth or maybe a third were turned in. Nobody really knows. Or look at, my book, Gun Control in Nazi-Occupied France. About maybe 1/5 of the hunting guns were turned in, even though you had the death penalty as punishment for not turning in your guns within 24 hours of the Nazi command to do so. And then if you want to say, okay, then we'll grandfather the ones that exist now. We'll require you to register the guns if you have them now, but then no more after that. You can look at New York, and what was it? A five-figure number that were registered, very low. Yeah. Maybe a fifth were registered. California, maybe 2%. I don't know. Nobody really knows. And so even if that's Northam's fallback to the fast law bill, the SB 16. Oh, we won't just ban them all, then we'll let you register them. Nobody's going to register them. Hello. So what's being proposed is, once again, to wage war on law-abiding citizens who have done nothing and to turn them into criminals. And, there you have it. They're not committing violent crimes. And then, as you say, there's the criminal justice reformers wanting to we can deregulate a lot of stuff like marijuana, or we can let people out of prison who are there for property crimes, which is another proposal. And so let's let them out and make room for gun owners.
Yeah, it's amazing. It's replacing the war on drugs with a war on guns, and I have a feeling it's going to be about as successful. I want to ask you something, Steve, and I don't want to put you on the spot here, but as we look forward to what might happen here in 2020, I think it's a fair assumption that a lot of these bad bills are going to become bad laws and are going to be subject to court challenges. In the Fourth Circuit Court of Appeals, which is the controlling circuit for Virginia, the court has already ruled in a case out of Maryland a few years ago in a really, really atrocious decision. The Fourth Circuit said that not only was Maryland's so-called assault weapons ban fine, but that there is no constitutional right to possess an AR-15 or a semi-automatic rifle because it is, quote, like a machine gun. If that's the controlling law right now over Virginia, do we have an opportunity to even challenge a so-called assault weapons ban if one is put on the books in the state?
Yeah, absolutely, we do. That's the Colby case. And if you look at the Maryland statute, that's not what's being proposed in Virginia.
Okay.
If you look at the generic definitions that Maryland set forth for what was going to be a banned gun, it had to have two features. And the only features they mentioned were that it had a flash suppressor or a flare attachment, that it had a folding stock, not a retractable stock, though. Pistol grip was not on there. So if you want to apply that case to what's being proposed for Virginia, it doesn't even apply to the same definitions. Now, notice, as bad as that court decision was, it did not say that anything the legislature calls an assault weapon is valid. So if you look at what they actually upheld, it's not the same thing that's being proposed in Virginia. And if Virginia wanted to enact the small number of generic definitions that Maryland did, go to it. That's because what's being proposed is a lot more radical than what passed. Not to mention Maryland's, or rather the Colby court, basically rejected the Heller decision from the Supreme Court. And there's always the possibility that the Supreme Court's going to take on one of these cases.
Yeah, absolutely. And we've also seen, I think, some changes in the Fourth Circuit since the Colby decision came down. It is not one of these circuit courts of appeals that has now flipped to a majority of Republican-appointed judges, but I believe we're two judges away from that being the case. I think one more appointee, it's a tie, and then one more, you've got a Republican majority. So the three-judge panel that heard Colby and upheld Maryland's gun ban a few years ago, we may get some very different judges considering Virginia's upcoming law.
Yeah, but keep in mind, though, the law was questioned in the three-judge panel decision, and it was written by a Democrat appointee who said strict scrutiny should apply, and they tried to remand the case back to the district court. And in the meantime, the full court granted en banc review, and the same judge wrote a dissent in that case. It was a Democrat appointee dissenting from the en banc, the full court, which upheld the law. So it sometimes it seems that who appointed them makes a difference, but sometimes it doesn't. The oral argument in that case, this one Democrat appointee was very, very vocal about making clear that he had guns in his house and magazines that they wanted to ban, and that he thought this was an affront to the Second Amendment.
That is an excellent point, because sometimes you're right. We do look at this as if it's, red versus blue. Judges are not supposed to be partisan, and that's actually really, I think that's really encouraging news for gun owners to hear that, yes, there's at least one Democrat-appointed judge on the Fourth Circuit who does seem to get it, recognizes that the Second Amendment is a real right, that Heller is a valid Supreme Court decision. And bottom line, Steve, it sounds to me like 2020 is going to be a very busy year, not only in terms of the anti-gun legislation that we have coming down in Virginia, but also in terms of the pro-Second Amendment litigation that is sure to follow.
Right, and this backing up to the political process, there's got to be some rural Democrats in Virginia that these policies are not going to go well with. All it takes is a few members to vote differently. Mm-hmm. And if you compare what's happened in Democrat-controlled Illinois, for example, every year they seem to dodge the bullet. There's never been a statewide assault weapon ban there or a magazine ban. Or the state of Delaware. Last year, you had the second time a so-called assault weapon ban was proposed, but it didn't even make it out of committee. And so you've got, I think there's got to be some rural Democrats listening to their constituents, because this is all over Virginia. There's only a few enclaves that are not either Second Amendment sanctuaries or counties that have declared themselves in favor of protection of Second Amendment rights.
Absolutely right. And yeah, the fight is just beginning. It is not over by a long shot. Steve Halbrook, Second Amendment attorney and scholar. As always, it is great talking with you. Thank you so much for spending some time with us today.
Yes, sir. You too, Cam. Talk to you soon.
All right. We'll do this again very soon. Steve Halbrook joining us here on Bearing Arms, Cam and Company. All right. Now, coming up on tomorrow's program, we're going to have an all-email edition. You're going to keep me company with your questions, your comments, cam.edwards@bearingarms.com. That is the email address to use. But before we leave you today, let's get to our Armed Citizen story, our good deed of the day, and, of course, our recidivism report. We'll start there, actually, from the state of Virginia as well. There was a double shooting at a Denny's in Manassas, Virginia, Northern Virginia. And according to the Prince William Times, 2 men charged in that double shooting on December 26th that resulted in the death of a DoorDash delivery man were on probation for earlier crimes at the time of that incident and had violated their probation on multiple occasions, according to court records. Yeah, well, we've got all kinds of, politicians in Virginia who are merrily and happily looking to introduce all kinds of restrictions on the legal gun owners in the state. What happens when you're a criminal who's arrested, who's convicted, and who violates your probation afterwards? Ryan Thomas Walker is 22. 22-year-old Jordan Anderson taken into police custody on December 29th for the armed robbery and shootings at a Denny's restaurant that killed the 56-year-old Yusuf Osgar, who was a Manassas father of 2, left a 34-year-old man from Rixieville, Virginia, seriously injured. According to the Prince William Times, Walker has been on probation since April of 2018 after serving a year and a half of a 3-year suspended prison sentence for a July 2016 robbery in Manassas. He was charged with robbing a woman at a gas station on July 11, 2016, stole $1,000 in cash, a gold bracelet valued at $5,000. Court documents show that the Virginia Department of Corrections sought to have his probation revoked in June of 2019 after he repeatedly violated the conditions of his probation. Walker failed to appear for 13 random drug screenings between October of 2018 and June of 2019, tested positive for pot 3 times when he did show up for his drug test. He had not made any of his court-ordered restitution payments, which totaled $6,000. But on December the 5th, Prince William County Circuit Judge Carol Weimer sentenced Walker to, quote, time served, meaning that he would not return to prison to serve the remainder of his suspended sentence and would instead remain on probation. So, in other words, he violated his probation more than a dozen different times. And when a judge said, well, we could send you back to prison, but you know what? I'm just going to let you get away with it. That's what happened. Meanwhile, Anderson was also on probation at the time of the shooting, according to the Prince William Times, served 2 years in prison after committing 2 home invasions in April of 2016. He was released on supervised probation September 9th, 2019. 10 days after his release, he tested positive for opioids in violation of his probation, tested positive for marijuana. A month later, got a speeding ticket in October, charged with reckless driving in October. He was arraigned. Actually, he was due in court February the 3rd on charges connected with that reckless driving crash. Now he's shown up in court, charged with 1 count of murder, 1 count of malicious wounding, 2 counts of using a firearm in commission of a felony. So again, both of these individuals on probation, both of these individuals had violated their probation, and neither of these individuals suffered any consequences from the state of Virginia for doing so. And mere weeks after one of these guys was told by a judge, no, you're all good, he and his accomplice, again, allegedly go into this Denny's, ordered 23 diners and staff members to lie on the floor, demanded they take out their wallets and cell phones. The delivery driver was entering the restaurant just as the suspects were leaving. He was hit over the head by one, shot by the other, according to prosecutors. Unreal. And again, we've got far too many politicians in Virginia who think that you and I and other legal gun owners are the problem instead of getting tough on repeat offenders like those two individuals. Now, let's get to today's hero of the day. Story, we've got it at Bearing Arms right now, as a matter of fact. Limestone County, Alabama woman using a firearm to defend herself after a domestic situation ended up spilling onto an interstate there in Alabama. Apparently, this woman was involved in an altercation with an acquaintance at a home. She fled the home. This guy takes off after her, tries to run her off the interstate, and then approached her car. That's when she drew her pistol. Did not have to fire it. As soon as this guy saw the gun in her hand, all of a sudden he took off, had somewhere else that he needed to be. Deputies later found the individual, 34-year-old Charles Baker, at a nearby intersection. They searched his vehicle, found meth in the car. He was taken into custody. Being held right now, I'm not kidding you, $2,500 bond. That's it. That's it. So the woman who acted in self-defense without firing a shot, she's not facing any charges. Baker is facing charges, but unfortunately will soon be back out on the streets. And I hope that this woman in question doesn't let her guard down, because hopefully this guy leaves her alone. I would not be 100% confident that that is going to be the case. All right, on to our good deed of the day. North Carolina. Channel 9, WSOC TV, with a story out of Durham, North Carolina. About 3 o'clock in the morning, according to WTVD in Durham, the intersection of Fayetteville and Pettigrew Street, Officer Stacy DeSantis was conducting a wellness check when she saw a car stopped on a set of train tracks. It's 3 o'clock in the morning. Might not think, any trains are out going down the tracks that time of night, but there was one anyway. DeSantis noticed a train approaching. She tried to move the car. The female driver inside reported that the car was not moving. The car had broken down. Authorities said DeSantis took a patrol car and the driver to safety away from the tracks. The jurisdiction where Officer DeSantis works, North Carolina Central University, said that she acted, quote, quickly and with selflessness after seeing an individual in distress. Her actions are to be lauded and commended. No injuries were reported. I imagine that woman might need to find a new car at some point, but because of the actions of Officer DeSantis, she is safe and sound. All right, that is going to do it for this edition of Bearing Arms, Cam & Company. Again, a reminder for you that on tomorrow's program, you are going to be keeping me company. cam.edwards@bearingarms.com. That is the email address to use if you want to send questions, comments, criticisms, I suppose, compliments. Those are always taken as well. Anyway, we will hear from you tomorrow on the program. Thank you for joining me today. Have a great rest of your Thursday. We'll see you back here soon with another edition of Bearing Arms, Cam & Company.